have Brittany Darling here with me.
Hi, guys.
And Brittany is our Client Services Director at Emily Hicks Law. And if you're a client of mine, you may have heard from her, or you're likely to hear from her in the future. She wears a lot of hats for us and does a really great job.
Thanks, Emily. I'm so happy to be on the show with you today. If y'all are anything like me, I had no idea what estate planning was, what it meant. And honestly, I thought it was just something you did when you reached a certain age or you had a certain amount of money in your pockets.
Right.
But I was wrong. I've learned that even if you're just over the age of 18, you have an estate, whether it's a bank account or a tiny stock account. Some planning is necessary even when you're 18 years old.
That's right.
But today, for the very first show, we are going to talk about the basics. So we're going to call it Estate Planning 101 today. So Emily, the first question is, what is an estate exactly?
Yes, it's a good question, because I had a phone call with a potential client a couple of days ago, and she really wanted to get some documents done, and she knew that she didn't have anything in place, and she has a chronic illness, so she was very concerned about the timing of the process and all of that. And she said, but I don't really have an estate. I'm not a wealthy person, and I get that a lot. A lot of people don't think they have an actual estate because they're not wealthy, and that's absolutely not true. And I say, if you have a bank account, essentially, you have an estate, because what happens when someone passes is, if you have assets that are in your personal name, then there's no way to transfer those assets anymore after you pass. So that essentially becomes your estate. And so believe it or not, even an 18-year-old college student, has an estate. So, oh gosh, I just really lost my train of thought on that. So yes, so it's important at every age, and you really, once you become an adult, you have to start thinking about that. And college kids going off to college even have estates now, so it affects nearly everyone, every adult that has any type of asset in their name.
Yeah. So why is it so important that we think about our estate and our assets ahead of time?
Well, we have different life stages, right? So I just kind of mentioned, at the very beginning of adulthood, when you perhaps go to college, or you turn 18 and you go to work, or whatever it is that you go do. There's a certain time in your life that you need certain things. I call it my college kid package. A lot of parents come to me and they say, they're going off to school and I don't have any access. They don't give me any access to anything anymore. I can't even make a doctor's appointment for them.
Yep.
And I say, yes, they are an adult now and they can do what they want to do. So, there's a certain amount of planning that goes for each life stage, I like to say, because they're in that stage of life, and they're still really pretty dependent on parents, unfortunately, for some of us. But they're in that stage. And then when you get a little bit older, like you're married, you have children, you need to think about guardians for the kids. That's a really big issue for people, because it's not very likely that something's going to happen, to the two of you, but it is possible. People travel with their spouses.
Yes.
You're in cars together,
planes together.
You're on planes together. You're on trips together. You really don't know. You just really can't predict the future. So, that time of life is another stage where you need another sort of a different type of plan. You need to think about guardians. You need to think about, all of the documents that you need for minor children, and what would possibly happen to them if something, if it's every parent's nightmare, but if the worst is, would happen to you, then you need to have a plan in place, because it's not just about if the two of you were to pass. I mean, there's also a scenario where you might be incapacitated, which is, in a hospital. You can't speak for yourself. No one's going to know what your wishes are unless you put them on paper and make it legally binding. So that's right. That's that stage of life. And then as we age, things change again. And as we get older, we start depending perhaps a little more on our own children to take care of us. So the roles reverse, and that's a really interesting place to be. And that's, I found myself in that place, in the past couple of years, and it's really strange. It's really strange to now be the one giving advice or helping your own parents, make decisions and helping them take care of themselves, or you taking care of them. So that's a different plan. Once yes. You're planning for retirement, that's a entirely different phase of life. So you're going to need to address your plan, address everything at each stage of your life, at each phase, I should say, of how you progress through. So It's very important.
Well, let's go back and revisit the situation where you can't necessarily make decisions for yourself. That'll be a good starting point for us to talk about what types of documents are involved in an estate plan. So let's talk about a situation where perhaps you're married and you've been involved in a car accident, and the time comes where you are in a situation where you cannot make financial decisions for yourself. You cannot make healthcare decisions for yourself. So how can you prepare for that particular situation?
That's a great question. And, that brings me to say, when we sit down with clients or potential clients, and I explain to them there's really two types of estate planning. There is the planning for what happens after your death, and there's the planning for what happens while you're still alive. And I always argue that that's the most important planning that we can do, because that involves a lot of things, and that's really important. It's a really important to take care of yourself while you're still here, because the other stuff is just stuff, right? So to do that, and to create a plan for, if you're incapacitated, that really starts with a power of attorney. And I should say a durable power of attorney, because what makes it durable is that it will survive incapacity. So you want to make sure that's something that your document absolutely says, that it is durable, because you want to have it when you need it, and you want it to work when you need it most, which is when you cannot make those decisions for yourself. And the power of attorney is going to be one of those documents that is extremely important, and I always say it's probably the most important document that you'll sign during your estate plan. But it's one of those things that covers a lot of different things, but it's your financial stuff. So, if you're in a hospital, you're incapacitated, you're just unable to make decisions for yourself in an accident type scenario that we're talking about now, that trusted person, and a lot of times it's a spouse, or if you're not married, it's going to be, perhaps a brother, sister, parent, family friend, a trusted person. Hopefully that a very trusted person, because you're giving them a lot of authority, right. But on the same hand, they are also a fiduciary to you, and that means they have a duty to act in your best interest. So that's something that's really important to not forget, because it's a really scary document to sign, because you're signing, basically you're going through this document and it says, okay, this person has the power to conduct bank transactions for me. They can buy and sell real estate. They can manage my stock portfolio. They can do all of these things. And the reason that, they can is because you may need all of those things done.
Yeah. But
it's very scary. So, understand that whoever you nominate will also have a fiduciary duty to you. And that means that they have the duty to act in your best interest. So it puts that responsibility on them. So it's not as,
right.
it's not carte blanche, so to speak. It's not like, oh, I can just go and drain mom's bank account and do whatever I want. You can be prosecuted for fraud for that. So
yeah. Let's chat about a different situation. So, accidents can happen at any time, but I think the scenario that most of us will likely find ourselves in is, taking care of an aging parent.
Absolutely.
And an aging parent who is approaching the point in either an illness or a disease where maybe they can't or shouldn't be making decisions for themselves. So talk about the power of attorney in relation to that particular situation.
Yeah, that's the most common situation that we see at our practice, and the most common situation that most people find themselves in when they need a power of attorney. One important thing to remember is that when you have a parent or yourself, it's really important to get these documents in place before these types of diseases set in and the person is no longer able to make that decision for themselves. I mean, I have a situation right now where I have a married couple that really needs to get a lot of things in place, but the family thought, okay, it's kind of a funny story. It's not funny in that it's, haha funny. It's just the family thought this whole time that the mom was the one that was going to probably pass first. She's always been in bad health. She has dementia. Everyone had planned on that happening, okay? Well, lo and behold, the father has unfortunately mixed some medications. He's had some really terrible complications with some, I think it's saw palmetto, I think he said. I'm not a doctor, I'm not giving any medical advice, I don't want to say anything, but he has mixed something and didn't realize that it could cause kidney damage. So he's in kidney failure now, and hospice has been, he's under hospice care now. So it's more of a dire situation for him, and this has been very unexpected, and they have nothing planned. They don't have anything in place. The challenge here is, how do I get, if he passes and they have all of their assets jointly titled and he's gone, now they're titled solely in the mother's name, and how do we get power of attorney if she cannot sign a power of attorney?
That's right.
So in that instance, what would happen if she doesn't have capacity to sign? It has to go to the court. So you have to petition for guardianship. And that's what we really, really, really want to avoid.
Okay.
That's kind of the whole point of this, because if you don't have anything and there's no one that can legally act on your behalf because you haven't prepared any power of attorney or anything like that, then that is what you have to do. You have to petition for guardianship over the person, and that's very costly. That you have to go through the court system for that, and that's nobody wants to have to do that, So that's what we're trying to avoid here. But yeah, it can get really dicey, because coming back to my original point was, do it before you need it, because you're not always going to be able to do it after you need it. But yes, that is it's a common, I'm saying so much. Sorry, whoever edits this. But it's a common time that you need it, is when you're caring for your aging parent and they can't make decisions. The other, tricky part about it is these diseases like dementia and Alzheimer's and Parkinson's and all of these things that we're seeing so prevalent now. Unfortunately, there's an element of paranoia that comes along with those.
Yeah.
So that makes it even more important to get this stuff done beforehand, because they're going to, almost everyone that I've worked with has kind of gone through that, where they think they're stealing my money, they're trying to take my money, I don't want them to have access to my money, all of these fears, because they're losing control, and it's a really, really hard time. They're losing control of their faculties, they're losing control of their mind, and it's scary, and they don't want to sign these things after that fear and that paranoia sets in. So even more important, get it done while you're healthy. I could just really, if I could urge you to do that, because you just don't know what's going to happen, and these things set in so soon before even the symptoms appear. So it can be quite a challenge. It really can be.
Let's move on to some other documents involved in estate planning. We've established that the power of attorney is super important. Emily, what are other documents that in your planning sessions, what else do you talk about with your clients?
Yeah, so if we're kind of continuing on the line of what you need to plan for while you're still alive, all of the documents that you need for that piece of the puzzle, it's going to be your power of attorney, obviously, a durable power of attorney. You're going to have a living will, which is your advance directive. And that's going to discuss how you want to be treated medically if you are incapacitated. Out of all of the people that I've represented and helped to do estate plans, I really only had one client that didn't want to sign a living will, that they did not want to be taken off of life support ever.
Oh.
Yeah. So most people, they say, oh yeah, I don't want to be artificially prolonged.
Okay.
If I'm in an end stage condition, I'm not coming back, it's a persistent vegetative state, I don't want to be kept on life support. Most people say that, and obviously this is an individual choice. You can you can do whatever you want to do, but I have had one couple that said, no, we don't want to be taken off.
We basically want to try to live forever.
They are going to live forever. So that was really interesting, I thought, because they stick out, because they're the one that say, no, we don't want to do that. But
so, Emily, should this person who's making this decision for you and as a part of your living will on this document, I'm guessing it should be your spouse.
Yes.
But can it be someone that's not related to you?
Well, so what you're talking about now is actually the healthcare surrogate.
Okay.
So in Florida, in most places, they call it like medical power of attorney.
Okay.
But in Florida, we call it a healthcare surrogate. We nominate the surrogate to make those medical decisions for us. If you trust your spouse, yes. Check your life insurance policies. I'm kidding. No, it's usually, you're usually going to name your spouse. If you're married, you don't have to. You can name whoever you want. But and then a trusted family member. Depending on what your individual wishes are, obviously you want to name the person that's going to carry out what you want to happen. Right. So if you don't want to ever be taken off life support, you better find somebody that is going to fight for that, because that's going to be pretty hard, to argue after a while. But
so in the case that I am putting this document as part of my estate plan. My husband has passed away. Could it be, and I'm, say I'm in my 60s or my 70s and my husband has passed away, could it be one of my children, could my children share that role? Or could it just be one of my children?
You can nominate both. And many people do like to do that. They want the kids to feel equal in all of
Okay.
these types of decisions. So we'll put co-surrogates, basically, and we'll
Okay.
just name both of them.
And that just means they have to make whatever decision, they have to make it together.
Yes.
They could not make it individually.
Right. So
Okay.
that's, I mean, unless one of them is unavailable, you know, you always kind of want to leave it a little bit open because you can't 100% plan on, you know, both of them being immediately available, you know, to
Okay.
you. A lot of times what we do with that situation, you know, for instance, the couple that I met with yesterday, they have a daughter in New York, they have a son that's local. So, you know, when we were going through it, you know, when we started our planning process, they were thinking, well, you know, our daughter's really kind of not cold-hearted, but she's the kind of person that would definitely pull the plug if needed. They, you know, and they joked about it like she could handle that decision. Like, we know she's capable of doing that. And this son, they're like, oh, I don't know if I want to put him in that position. So, you know, so I said, okay, well, we can just, you know, put the daughter first. That's fine. Then when we kind of went through and kind of started thinking about it, and then I realized she is in New York and may not be on hand, you know, immediately. Because that's the thing about the healthcare decisions is you really want to have somebody that's in close proximity if possible, you know, because her flying, you know, down from New York is not super close. I mean, it's not it wouldn't be a terrible journey, but you never know when you're in a dire healthcare situation, it just may not be feasible. So anyway, so we changed it and we named the son, and we're just gonna, you know, hope that he's gonna be able to get her down here in time. But really, it's a courtesy to them. We're naming them as, you know, healthcare surrogates, but you know, keep in mind that we have these other documents in place, the living will, which says how we want to be treated medically, so that we've already made that decision. They just have to carry out the decision that we have made.
Right.
And that's the courtesy part. You really, all of this is a courtesy to your family because, you know, when my mother got ill last year, you know, she had reached the point in time where she was no longer eating. So we had to make the decision of, do we have to put a feeding tube in? Do we do that? Would she want that done? We had never discussed that with her. She was only 67.
Yeah.
You know, she was one of those people that did not want to talk about any of these things. And she was just very, very private. And you know, once the disease had already set in, it was too late, and we didn't even see it coming. Right. You know, so we made the decision on what we thought was best and what she would want, which was not to prolong her life, right? But that's, you know, that's kind of a burden to carry.
Right.
I don't feel guilt about it, but you know, I can see how some people would if they are making the decision to end someone's life, essentially. You know, it's a hard thing to do. So, I mean, it's such a courtesy to have these decisions made so that, you know, they can say, Mom really wanted this or Dad really wanted this. We know this, you know, here's all of the documents. You know, this is what we're going to do. Which brings me to another document, which is the advance directive in the event of dementia.
Okay.
So this is another really important document nowadays. Dementia it's really become a very large disease with Alzheimer's and dementia and all of these, what they call dementing diseases that are affecting our brains. It's really, it seems to be an epidemic almost nowadays. So, you know, which brings all of this really to the forefront because the living will in the event of dementia is another document that I like to prepare for people because that really addresses that stuff, you know, with the feeding tube, with hydration, even, you know, most people listening probably remember the famous case about this. I believe it was in the 90s. I don't even have the right date on it, but it was the Terry Chavo case where she was on life support. The husband was arguing to take her off of life support, and the parents would not take her off. So
right.
it was this famous court battle, and it went on, and it was excruciating. And I think Janet Reno was like the attorney general at the time for Florida, and she got involved. It was crazy. So it really brought all of this, to the forefront. And with COVID, another, big issue that came up was the ventilators. People were starting to say, no, I don't want a ventilator put in. So that was another thing that we kind of had to think about with this type of thing. So, with the living will, it's going to talk about life support and whether or not you want to be artificially prolonged.
Mm-hmm.
With the living will in the event of dementia is going to talk about in the event of dementia, with the feeding, with the hydration, how do you want that to be? How do you want to be treated? Do you want to have limited, nutrition? Do you want to have none?
Okay.
And then those decisions are made too, and your family can just carry that out. So that was a very long-winded answer to what you thought was maybe a simpler question, but it's there's a lot of scenarios and a lot of different variations on what you can put in those. And some people like to beef them up even more than that. So we can do that too.
Yeah. I think we've all heard of a document called the will. But Emily, what makes a will effective? Let's kind of shift gears a little bit and kind of talk about the will as a document that after someone passes away, the will kind of comes into play. So talk about what a good will has in it.
Okay.
And maybe what a good will does not have in it. And we'll go from there.
Sure. So everybody knows they need a will. Like, that's the number one thing. When I see people, I pass friends on the street sometimes, and they're like, oh my God, I need to talk to you because I need to do my will, and I'm like, I know, yes, okay, we'll do it. But everybody thinks that's all they need. Like, that's just the end all, document that you're going to have. But, and it is important. I mean, it is an important document to have, certainly. But you really need to have certain things. You really need to make sure that it is, it says that it's your will, number one.
Okay.
That you are over 18. Okay. And you need to have witnesses, and you need it to be witnessed and notarized.
Okay.
You can, you can't really get around that because in Florida, we have certain standards, and our standards are actually a little bit higher than other states, in which, because I was reading this article yesterday about Aretha Franklin, who so I thought she died without a will, but apparently they found all of these wills, quote unquote. So she had
all of these wills? Yeah.
So what she did, now this is really funny. This woman had millions, I'm assuming. I don't know how she spent her money. She's the queen of soul, right? Yeah. So she, I'm sure, had access to attorneys, but for some reason hand wrote her will. And it's like, I read it yesterday. I was like, I can't even read this. Her handwriting was not very legible. But she wrote out this document. It's maybe like 8 or 9 pages, something like that. Like, the house in this area, I want this to go to my son. And, she goes through the whole thing. And I believe she was in Michigan. I think she was in Michigan. I don't know. Don't quote me on that, but that's where I'm saying she was. In Michigan, you can do that, okay? Or whatever state it was. We're going to pretend it's Michigan. You can do that. You can, whatever state she was in, you can actually just handwrite a will, sign it. Great. This is your will. Wonderful. Okay. You can't do that in Florida. Florida's like, a little bit more strict about what it wants to classify as a will, because you do want to have standards, for the documents so that people can identify that as an actual will.
Right.
So she wrote out this document. Like I said, it was 8 or 9 pages, had all of this stuff in 2010. Then one of the daughter or niece or some other family member literally found scraps of paper in her couch from 2014 that are like written out, and it's purporting to be a will where she's like changing things in her will, like a post-it or something. I don't even know. I didn't see these scraps. But it's something crazy like that. She just has these tiny handwritten notes of changing the will. And so now they're all arguing about that. And so, you know, I'm thankful that we actually have kind of strict standards in Florida so that we can identify what is an actual will. And you can't just have like, you know, post-it notes on your fridge saying, hey, I'm changing my will to give, you know, everything to Susie down the street. You know what I mean? So yeah, you need to have it as witnessed and notarized. And you need to actually say that this is your last will and testament, and it needs to be written down. So
so if Aunt Judy leaves me her car, she passes away, and she says, Brittany, it's in the will that you get my car.
Yeah.
Do I get the keys when the will is read?
You know this is a pet peeve of mine. You know that I hate this because when you watch these movies and there's all, you know, any movie about someone that dies, it's always like, you know, they go to the lawyer's office and it's this, you know, older, you know, man with all the law books, you know, in the library, and they all sit down for the quote reading of the will. They're reading of the will. Like there's this big reading of the will. It's all very dramatic, you know, like very Agatha Christie. And, but it doesn't really work like that, unfortunately. I mean, and I joke with people because there's a really good scene in that movie. It's a little bit older movie, I would say, Rain Man with Tom Cruise, and where it's all about the inheritance in that movie. And they, I think the lawyer, like, they sit down for the reading of the will, and he like throws the keys to the car to Tom Cruise in the movie. And I'm like, that would never happen, you know. It doesn't happen like that. So you're not going to get Aunt Judy's keys. Like, you know, the lawyer, I'm not going to throw them at you. You know, if you have a will, you know, what really that means is you're going to have to go through probate. And that's a really big aha thing for people, because they think, wait, I have a will. I don't have to go through court. You know, I've already decided everything. Well, that's not true. It actually, you know, we always say if you have a will, it will go through probate, you know, because that's what happens. It's not something that it has to be proved by the judge. It has to be authenticated. Okay. So, there was something else I was going to say about wills too. Oh, I was going to say another thing about Aunt Judy, which a car is one thing, but because that's just a personal, you know, item. But if let's say Aunt Judy had an IRA or a 401k.
Okay. Let's say she had both.
Let's say Aunt Judy really had a great retirement plan. And she decided maybe later on in her life that her niece Brittany is just the best thing, and she wants to leave all of that to her, to you. But Aunt Judy forgot to, and she puts that in her will, okay? So she's going to write that in the will that Brittany gets all of the assets from the IRA and from the 401k. Okay. However, Aunt Judy forgot to update the beneficiary designations on the IRA and the 401k, and they are still in somebody else's name. Okay, what happens then?
That's a great question. What does happen then?
You don't get the money. It doesn't matter what the will says, because those assets pass outside of probate. Okay,
so interesting. So you're saying if Aunt Judy writes her will, there are certain things that you can put in your will that go to certain people, but then there are other assets that pass outside of the will altogether. So the will doesn't matter about them.
Yes.
So let's cover maybe what those maybe top assets would be that maybe don't go through your will.
Okay. Yeah. Anything that, well, there's a couple of things. Okay. So what I'm talking about right now is anything that has a designated beneficiary. All right, that's going to be a life insurance policy.
Okay.
That's going to be a 401k or an IRA. So all of those things you fill out a form. Hopefully you've done this and kept this up to date with your company, and you're going to name your primary beneficiary, and then you're probably going to put an alternate. Okay, so if the primary isn't around, or isn't available, we'll say, has passed, whatever has happened to them, then you have your alternate that's going to receive those funds. And with an IRA, for instance, what happens is an inherited IRA is what happens with that situation. So if you inherit the IRA from Aunt Judy, now you own another IRA. And so it's just going to start a new IRA for you. Okay. And there's some new laws about that have changed recently that we won't get into today. But just to kind of say, that because we're talking about it, I want to just point out to people that when you do inherit an IRA nowadays, that's going to have to be paid out within 10 years, which is a really big change from how it was before, where you could keep it. Not if it's a spouse inheriting it, but if it's a child or, another person, then you actually have to have that IRA pay out within 10 years.
Okay.
So that's kind of, a new thing to think about. But yes, so going back to anything with a designated beneficiary, like your life insurance, it doesn't matter what the will says, because they're not reading your will. Those beneficiaries are already set, and that's what's going to happen. So there's no really arguing with that. It's just not going to happen. We see it a lot with second marriages, or perhaps third marriages, or new girlfriends, or old girlfriends and boyfriends, where people will change them and then they'll forget to change them, or they don't know. I know. We had a really bad scenario
ugly.
Where
it has potential to get really ugly.
It has gotten ugly because we had an old girlfriend inherit an IRA, and the new wife was not happy. She was, really, really, really unhappy about that. But it's what happens, and you can't change it other than changing those beneficiaries. So you got to keep that up to date, especially if you have an active dating life, or whatever is going on for you. So that's one scenario where it's going to pass outside of probate. Another scenario is where you own things jointly with somebody else. So like you and your husband, you probably own your house together, right? You probably have a joint bank account. So if something were to happen to him, then you're going to be the title holder for that. And in other scenarios with that too, a lot of people will put their kids on bank accounts, which I don't really love this all the time.
Right.
Depending
Tell
on
us why, Emily. I think we've talked about this before, but to remind everyone why that situation could also get just a little hairy.
It can, because let's just say this happens a lot. When people get older, they will let's just say they'll put their daughter on their bank account. Well, if they're
and it happens with the best of intentions.
Absolutely,
it's something. It means your daughter can help you pay for whatever needs to be paid for. If just give them access to a checkbook, and they can pay for bills. They can do all kinds of things. However,
it's super easy. It makes it to where now she can pay the bills, can handle the financial stuff for me, no problem. And to be quite honest, it's a lot easier sometimes than dealing with a power of attorney in a bank. Sometimes banks don't really like powers of attorney. They're scared of that. So just, know that. But they have to honor it. I mean, it is Florida law. But so putting them on title is like, just put them on, that'll be easy. So, and that's fine, as long as nothing happens to the daughter. Let's say the daughter gets in a car accident, and it's her fault. Maybe it's, she missed a stop sign. Who knows? She gets in a car accident. Now there's a judgment against her, a money judgment against her. And the attorney is going to then say, okay, we're going to execute what's called execute the judgment, which means find the money to pay it off, right? For their client. And so, what happens in that circumstances, you have to, tell the other party what all your assets are. When you're in a lawsuit, you don't have any privacy. Okay, if there's a judgment against you, then you have to list out all of your assets. It is very brutal and painful. So, so that they can effectively execute the judgment and collect money for their, for the person that was injured. Mm-hmm. So if that happens to the daughter, then potentially that bank account becomes an asset. It's jointly titled. So that could be a possible issue. That would be a worst case scenario. And so I don't always love that part of that type of planning. I mean, there are other ways, to get around it, but it's really common. And, I'm not going to, say, oh, don't ever do that. But just know that there is a little bit of risk when you put other people entitled to your assets. Then you're essentially kind of opening yourself up to any potential risky behavior that they may have in their lives. So
So let's move forward and let's dive a little bit deeper into estate planning documents. We've talked about a power of attorney, why that's so important. Why it's important to have a will, although it does have to go through probate, and that's not a fun process. So
it can be an expensive process.
It can be an expensive process, and it's a long process. So how can a family kind of avoid some of that headache? What is another way that they can kind of go further in estate planning and avoid probate?
Okay. Well, that's the number one question that we get, right? So that is going to bring in the trust. And what we're talking about is a living trust or a revocable trust. It's the same thing. People always say, are they different? Why is it living or revocable? It's really just a semantic, like if you like the word revocable better if you like living trust better. It just means you've made it while you're still alive, and that distinction is important because there are trusts that can be created in wills, but those are testamentary because they're after death, trusts that are created on your behalf. But if you're creating it while you're still alive, it's a living trust or a revocable trust, and that just means you can revoke it. You can make any changes you want. A trust is simply an agreement that you put together to hold title to property. I mean, it's to put it down as simply as possible. It becomes sort of a title holder to avoid probate.
Okay.
Yeah. So it's a really important document that we put together. There's a lot of other benefits that come along with creating a trust as well. I mean, there's a lot of wonderful powers that you get, kind of mimicking a little bit in the power of attorney. Some of that stuff is in there. It gives you, there's a HIPAA, at least in our trust, we have a HIPAA authority and things like that. So it gives you a lot of, it grants you a lot of power, and it's a really great document to have, even if you, don't have a lot of assets to quote unquote fund it, because, people say, well, listen, Emily, like I'm not Donald Trump, I'm not wealthy. Right. I don't need a trust. I'm not a trust fund, person.
Right.
What are you talking about? Because when you say the word trust, it automatically makes you think of like, I don't know, like super rich, people, right. Trust fund kids, what I mean? But it's really not,
it's really just a tool. It's a tool that
absolutely.
You can use as part of your estate planning, that it's just another level of making sure what you want to happen, it happens to your assets.
Exactly.
It's your decision.
Yeah.
And you get to put your decisions in that trust. And it's very specific. You can get more specific in a trust than you can in a will.
Absolutely. Well, you have a lot more control. So I'll kind of run through. I told you I had this crazy case right now where I had a client that we did his estate plan last November, and he did a trust, and we funded all of the real estate in the trust, and we did everything we needed to do. Luckily, because he had a fall. He was only 58, and very unexpectedly, he had a fall, actually had a brain aneurysm, and he died. And it was just, one of those crazy type of accidents. Well, he had two beneficiaries, a daughter who has substance abuse problems, and then a stepdaughter who was, responsible, working, has her own life, her own kids, her, everything. Well, one thing that we did, I made sure that we did, because after having met him and planning with him, knowing that she had a substance abuse problem, is we obviously could not name her as the successor trustee. So what you do with a trust is you're your own trustee at first. So he was unmarried at the time. His wife, unfortunately, had passed from COVID. So if it's a married couple, we'll do a joint trust, a joint revocable trust, and both are co-trustees. And then if one person passes, the other person remains trustee, sole trustee, and has all of the power. If it's just one person, then they're just going to be the one person, the sole trustee. Okay. Now, you really want to name a successor trustee, or two or three, after that, because, you need somebody. You need your backup person. Well, and that's kind of the point, because when you do pass, that person, it kind of becomes like your executor of your will. It's usually the same person we name as a successor trustee is going to be the personal representative, is what we call it in Florida. We don't call it executor of a will. But anyway, that's going to be, that person. And so we named the stepdaughter as the successor trustee because she was financially, stable and responsible. And what we had built in with the trust is the substance abuse provisions, where if you have a beneficiary that has a substance abuse problem, we have all of these protections for that. Because unfortunately, that's a really prevalent thing that happens in families nowadays. It's really sad. But, you kind of have to plan for all of these scenarios. And that's the beauty of the trust, because you're able to do that. You're able to really look at your own life, look at your own family and what's going on with it. And then we can build that in based on whatever's happening with you, you know? And even if it's not happening now, it can still be in there to protect you from possible future incidences like that, so we just never know. I mean, unfortunately, we don't always know what's going on with our kids, He knew, so we were able to plan for that, but, you don't always know. And, and you can't always anticipate what's going to happen with them. Like, for instance, if there is an accident and somebody becomes disabled, and they get on benefits, on government benefits. This is a really big deal right now. So if you are on government benefits, you don't want to inherit any money because they'll kick you off your benefits, right? So there's a special type of trust that you create for that. Well, and you can do that in a will as well, but if you have a really well designed trust, then it can anticipate that type of scenario for you too, and say, okay, if any of the beneficiaries are on government benefits, then we're going to create a supplemental needs trust, or which most people think of as a special needs trust. And that's a trust that's set up for their to supplement their needs, but it doesn't replace what the government benefits provide to them, because they want to remain on those programs for as long as they can. So there's just there's just so many great benefits to trust that, you don't know that you need them, or you may not even need them, but they're going to be there. Hopefully, if it's a well-designed one, it'll be there if you need it. So it just anticipates a lot of things, and it avoids probate, which is very nice.
So here's a question. So if a typical family is looking at creating an estate plan, they've done their POAs, they've done their will, they've established a trust, what are what are some situations where those documents need to be changed or revisited, and kind of what's the process of making changes?
Yeah, that's a really good question, because it's really hard to, like we've been saying the whole time, it's really hard to predict the future.
Yeah.
It's really hard to plan for what might happen or what we think is going to happen, because it very rarely does happen that way. So I always say, 10 years is a really long time to think, ahead. And I don't really think you can do it very accurately. So I say 3 to 5 years. Every 3 to 5 years, you need to take a look, or if there's a big life event that happens, but every 3 to 5 years, take a look at your plan and say, okay, are these the right people in this situation? Are these the right people for successor trustee? Or is this the right person for my power of attorney? Because I tell you, when I started out with my own planning for my own family, those people have changed because life has changed, right? So, the people that you may have counted on, I have a new client right now. She's one of just the sweetest people I've ever known. She is a wonderful, wonderful human, and her mother just passed. So we're redoing all of her documents because she has a young child, and her mother was the one that she had nominated for everything. And so we're going to have to revisit that. And she's kind of having a hard time, deciding, well, who's it going to be? Who do I want my kid to grow up with if I can't be there? And it's a really hard decision. It's a really hard thing to trust someone so much. But yeah, I mean, every 3 to 5 years, you need to take a look and just say, okay, are we all in the same place here? What's changed? And with the guardian nominations especially, I mean, because so much time passes from when they're tiny babies to, teenagers, a lot can happen during that time. So, and sometimes too, when you have multiple children, like my sister, for instance, her oldest is 20 now. So, we joke about that I'm no longer getting the young ones if something is, ever happens with her and her husband, because they don't want to move here. They don't live here. They don't want to move here. They want to finish out their school. They want to, be where they are. And so that totally makes sense. And I have begrudgingly, relinquished that, duty. But I said, okay, fine, we'll let them finish school. But yeah, every few years, you just got to take a look and see what's going on. Obviously, too, if you move to another state, or you have any type of life change, then you just need to make sure you're updated accordingly. And just one thing with that, I have a lot of people. There's a lot of people that move to Florida now. Okay, we have a lot of new people. Yes. And we've always had a lot of new people in Florida. But it seems like since COVID, it's just been, kind of crazy. Mm-hmm. So I do get this question a lot of, what do I need to do? Because I have my New York documents, or I have my, Pennsylvania documents.
California documents.
California, yes, California. I've seen more and more people from, which is kind of funny. So yeah, you do need to have stuff that's going to be valid in Florida. And so, I encourage you to take a look at everything. And if you have a trust, though, I will say this: if you have a trust that's already set up, your trust can travel with you. I had a client come in just the other day, and they had all their stuff done, all of their docs in place, but we did redo all of the docs for Florida, but their trust was already funded with their assets, so there really wasn't a need to create a new trust.
Okay.
I looked it
That's
over.
Good to know.
Yeah, so you don't always need to redo everything from scratch, but your power of attorney, your healthcare stuff, you want it to be Florida compliant, because you just don't want to have any issues with that. And that stuff is, it's too important to, especially the power of attorney, because we have different laws in Florida that are, and I looked at theirs. Theirs was from, I don't want to say, it was from your home state of Alabama. So, but I hated it. I thought it was super confusing, and I thought if I don't like how this is written out, then no financial institution is going to understand what it's trying to say. So yeah, we have very specific things in Florida, especially with the power of attorney, that you need to have in place, because it's just not gonna. You want to make sure it's done the way it needs to be done. I don't even know where we are now.
I honestly think we've hit on all the topics we wanted to talk about today. Estate Planning 101, we've talked about wills, we've talked about power of attorneys, we've talked about the benefits of a trust.
Mm-hmm.
It's you know, it might sound like a lot to take in. You know, if you're someone who has not kind of made the leap to do any future planning as far as these documents go, you know, I really urge you just to set up a 15-minute phone call. That's all it takes to get started. And it's one of those things where once you start talking about what means the most to you, it will make sense the path you need to take and what
Absolutely.
documents you need to put in place.
Yeah.
Because it's really all about, and a good estate law attorney will hear what's important to you, and they will make sure that what means the most is reflected in the documents that they put together for you.
Very true. Very true. It's really important to listen. It's very, very important because every family is so different. I have never sat down with a family, you know, that I said, oh yeah, you're just like so-and-so. It's just not the case ever. So it makes it really interesting and fun for me because, you know, sometimes we have blended families, you know, and blended
Right.
families have their own set of, you know, perhaps complications, because the truth of the matter is with a blended family is that the fear of accidentally disinheriting your own children is very real, and it actually happens quite a bit. You know, it's sad to say, but it so easily can happen. It actually, you know, I saw this own scenario with a friend of mine last year whose father died, and he had remarried. His new wife was not so cooperative in relinquishing the estate planning documents that the family thought that they, you know, that he had put in place. They are, you know, somehow missing now. And now, basically, they had jointly titled all of their assets together. And that means that she's the sole title owner.
Right.
So if she has, and a lot of times what happens in that scenario is when they have their own children, then those children inherit those assets, and the children from the first marriage get left behind. And so that can be a major issue. With,
I feel like we could spend an entire show on that exact topic.
Oh,
and maybe
my
we
gosh.
will.
We should, because blended families, that is a really good, it's a really good topic. But for the most part, you know, what you're going to want to look to have, if you want to avoid probate, you're probably going to need to put together a trust. You're going to need a will. You're going to need a power of attorney, healthcare surrogate, your living wills, you know, all of that stuff. That's the kind of stuff that you want to put in place to protect yourself and to protect your family. You know, there's so much that can happen, you know, while you're still alive, if you're incapacitated, if you happen to be facing healthcare challenges that, you know, affect your decision-making capacity and things like that. It's a crazy world right now. And, you know, there's just a lot of things that can go wrong. So I hope this has been really, really helpful for you. If you have any other questions, you can visit us at elderlawhour.com. This is Emily Hicks with Emily Hicks Law, and thank you so much, Brittany, for being here.
Thanks, Emily.
I appreciate it, and we will see you next week.